Yeah, we clean up trash. It's a shitty job, but we all have fun doing it.
Right.
You know, we talk, we laugh. And that whole vibe when he was around was just like the last
Morning,
couple weeks
Officer
was
Huff.
just
You are
horrible.
unmuted.
Oh, thank you.
Good morning. Today is Thursday, March 13th, 2025, and it's about 10:22 a.m. I'm reporting that our hearing did not start at 10 a.m. because the facility that we were trying to connect to is having technical issues. That's Carl Robinson facility. So we are now going to be hearing those two cases at 1 p.m. today. The hearing at 10 o'clock will start with Hartford Correction. 10:30. We'll start at 10:30. Thank you. Good morning. How are you?
Good morning. I hope you're waiting for Seeley.
Yeah. That's
Okay,
it.
they should be sending him up. I called a little while ago, so.
Great. Perfect. Sounds good. Thank you so much. Good morning, Attorney Dean. How are you?
Hey, you guys sent Seeley up, right? Okay, great. Okay, thanks.
Good morning. How are you?
Good. How are you?
Good. We've got a few together today.
We are together most of the day. It's already been a day.
Yeah. Oh,
Yeah,
there's always
but
technical difficulties, you know.
Always. It's never ending. But all right. Well, great to see you.
You too.
What is the worst? They gave you a plea offer 1 year. No time. Revocation. All right. Hey. Thank you.
Where's this pen? So that is.
Oh, that's my lawyer, right?
Yeah.
Okay.
So pro visit is on video.
Okay.
Sorry, Mr. Seeley, I'm just trying to get through some technical difficulties. I'm Officer Tricello. We can't start your hearing until exactly 10:30. It's about 10:27 right now, okay? So
Oh.
in about 3 minutes, we'll start, okay?
Okay.
All right.
I can't talk to my lawyer?
I'm sorry, did you want to speak to me before the hearing?
Yeah, I just wanted to ask you one question.
Do you, so the options, I guess, would be to continue the hearing in order for me
So-
to call you.
So it was supposed to be at 12:30, so my girlfriend and stuff was gonna be here, but now it's 10:30. I didn't know that.
I emailed her, so she knows.
Okay,
Yep, I
just-
emailed her earlier.
so I can't even ask you a question, huh?
Well, everyone, I mean, it's live streamed, so
Okay.
I wouldn't suggest.
I'm sorry, I was a little sick, so I barely could talk. I was like struggling to talk.
Oh, it's okay. Is it something that you would want to continue the hearing for? Or
No.
okay.
It was, I mean, I don't even care if anybody hears it. I just want to ask you a quick question. It was about the second charge about the program participation thing.
Okay. I already have, arguments that I was going to make as to that. But if there's anything that I don't cover when we speak about that charge, if you want to, is it additional information that you have?
No, it's just that that they said that I'm sorry, lack of program participation, but while I was there, even though what had happened, I signed papers that showed I was participating.
Okay, thank you so much.
Okay. Like in every group, you have to sign papers before the group,
Okay.
you know?
All right, thank you.
Thank you very much. Oh.
Okay, so we are going to get started. So I'm Parole Officer Tricello. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Mitchell Seeley, inmate number 305213. Today is Thursday, March 13, 2025. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
It is Mitchell. I'm sorry, I'm a little sick. I barely can talk. It's Mitchell Seeley 305213.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Seeley.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Seeley, can you please raise your right hand? You solemnly swear, solemnly, sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for the hearing now. So the first is I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, thank you.
Okay, so you do have important rights at today's hearing. The first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes,
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
yes, thank you.
Great. So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of program participation, the charging officer reported that on 4/29/2024, you were placed at the App Foundation in New Haven to address your use of fentanyl and or heroin. On 5/5/2024, approximately 4:20 p.m., you gathered your belongings and exited the building. You got into a newer model smoke gray vehicle and never returned back to Apt. Subsequently, you were in violation of parole condition number 1, release direction / program participation. On charge number 2, condition of absconder, the charging officer reported that on 4/29/2024, you were placed in the App Foundation in New Haven to address your use of fentanyl and or heroin. On 5/5/2024, approximately 4:20 p.m., you gathered your belongings and exited the building. You got into a newer model smoke gray vehicle and never returned back to Apt. Your whereabouts are unknown at this time. Subsequently, you were in violation of parole condition number 1, release direction / absconder. The state has also filed exhibits that have been remarked for identification purposes. I have Exhibit A, a remand to custody, Exhibit B, parole conditions, Exhibit C, notice of parole violation, Exhibit D, parole violation report, and Exhibit E, the App Foundation unsuccessful discharge. In addition, they also submitted an addendum to the parole violation report on February 5th, 2025, and that's also admitted into evidence and reads as follows. In reference to the parole violation report submitted by P.O. Fortuna regarding Mitchell Seeley, number 305213, the following applies. On 6/3/2024, the Board of Parole issued a warrant based on the report declaring the offender an absconder from special parole supervision. On 6/7/24, the case was transferred to FIU for investigation. On 1/31/25, Seeley was apprehended by FIU, leaving a residence in Bristol. Seeley was served with his parole violation notice on 2/4/2025 and signed the notice of parole violation, parole rights, and remand, and they were scanned into case notes on 2/5/2025. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
Perfect. And were you able to review the information?
Yes.
Great. I've also received an exhibit from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Is that accurate?
Yes, we had submitted some others as well. There was also
There was others.
yeah, I think there were 7 in total. It was Exhibit 1, which was the parole accomplishments and future plans. Exhibit 2, letter of support from Miss Anderson. Exhibit 3, letter of support from Mr. Harrington. Exhibit 4, letter of support from DJ. 5, letter of support from Mr. Skinner. 6 is letter of support from Joanne Skinner, and then letter 7 is letter of support from Veronica Rogers.
So actually, counsel, I don't feel like I received that. Do you have the email in front of you? Can you tell me when it was sent to me?
Yes, I should be able to.
And if anything, I'm just going to take a short recess to review all of it.
Yes.
Or
Let me
forward it
just see here.
Yeah, try to pull it up, please.
Yes, it was sent. Okay. Sorry.
Oh, I see it in case not. So, do you mind if I just take a quick 5-minute
Can-
recess? I do want to review
can-
all of it.
Can I
That's
just
fine.
tell you one thing, Miss, please? That letter that's from Veronica Rogers. That,
Okay.
I just wanted you guys to know that she's a retired correctional officer.
Okay.
Not that it matters, but
Yes, that's fine if you would like to take a recess to review the
Review it.
documents, but you have them
Maybe
with you?
I do have them. I'm so sorry. I just
Oh,
didn't.
no, that's fine.
I'll be right back.
No rush. Thank you.
I just feel like that might be a good thing for them to know.
Yeah, I can't remember if it was in the letter, but
Nah, she didn't put it, but I hope that the vibe is good. Like I don't kind of worried.
sorry.
I said I'm kind of worried. I hope the vibe is good.
Oh, yeah, she'll be back shortly.
Taking forever to print, so I'm gonna read just here.
Mm. Bless you.
Thank you.
So thank you, Attorney Dean. I did just review all the documents. I am going to admit all of them into evidence, that you listed, exhibit 1 through 7 for the defense. Do you need any additional time to submit any other evidence?
No, thank you.
All right, so at this time, we do not have any witnesses, so it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges of the evidence submitted.
Thank you. As to the first charge program participation, I would argue that no findings should be made. The allegations are that my client's conduct violated the APT Foundation program rules. However, the program rules themselves were not uploaded as a piece of evidence. So it's difficult to say how he violated the rules without having the rules actually there. So I would argue that no findings should be made because the standard has not been met for that charge. Additionally, my client did want me to note that while at the program, he was actively participating in all groups. He stated earlier he signed all papers at the groups showing participation. As to the second charge, absconder, that charge I just kind of have some general comments for. My client was placed at App Foundation to help him with his substance use disorder. He does struggle very heavily with addiction. He reports, unfortunately, when he got to App Foundation, he was confronted with drugs people actively using in the facility, and it felt as though it was an environment that wasn't supportive of his sobriety. Even though it is technically a treatment facility, he did confront a lot of people in the facility who were actively using and were, kind of putting that out in the open for others to see. So I did just want to make note of that. And at the appropriate time, I would also like to remark to his background, history, and future plans.
Thank you. Just going to take a moment. I'll let you know my findings. So for charge number 1, I did listen to the testimony today and I have reviewed the evidence submitted. For charge number 1, I am going to make a finding that you violated the condition of program participation. based on state's exhibits B, D, and E. Also, I just heard counsel testify that Mr. Seeley signed all the documents for the program. So I know I did not receive the program rules, but there is a discharge summary as well, which is exhibit E. So on charge number 2, I'm also finding that you violated the condition of absconder based on state's exhibits B, D, and E. So that does conclude the fact-finding portion of today's hearing. At this time, you will have an opportunity to speak to your background and history, and the purpose of this part of the revocation hearing is to determine what outcome I'll recommend. So counsel, would you like a statement?
Yes, thank you very much. Mr. Seeley's 43 years old, born and raised in Bristol, Connecticut. His primary sources of support are his mom, his father, who is currently in a retirement home, and then his significant other, Jennifer. Mr. Seeley and Jennifer, Miss Anderson, have reportedly known each other for over 35 years. She is 20 years sober and is a huge sober support for my client. Mr. Seeley also receives significant support from Miss Anderson's family, her mother and father, and then her children. She does report to own her own mobile grooming business, Jen's Mobile Grooming. Most recently, upon being released to special parole in December of 2023, my client successfully completed the Chase Center halfway house in January 2024. He was then sponsored by his ex-wife in Bristol. Unfortunately, this was not a supportive environment. It was a very negative environment. The two eventually got divorced, which that was completed earlier this year in 2025. Shortly after my client's release in 2021 to supervision, he established his own handyman business, MC's Any and Everything, out of Bristol. He recently changed the name of that company to Loose Ends and specializes in tree cutting and stump grinding. He reportedly assisted his significant other, Jennifer, as well with her mobile grooming business. Most recently, as far as treatment goes, from April 29th to May 5th, he was at APT. He received medication-assisted treatment in the form of methadone at Connecticut Counseling. And while I was in the community, he was going to 12-step meetings about 3 times a week up until he was remanded. He's been attending church regularly as well with his family. Upon reinstatement of special parole, he would like to be sponsored by his significant other, Miss Anderson, at the address that was provided in Bristol. When he gets out, he hopes to return to his business and continue supporting his business, Loose Ends. He also hopes to help Miss Anderson with her business. His partner's father, Mr. Anderson's father, is reportedly interested in becoming a business partner with him for his tree cutting business as well. My client's amenable to any and all treatment recommendations. He's willing to and plans to re-engage in the 12-step programs that had been very beneficial to him. I am asking for you to consider the soonest possible release for my client. Although this is an absconding violation, my client was doing extremely well in the community once he was out of the program. He maintained his sobriety for the full amount of time he was out there. He was staying out of trouble. This isn't a situation where he's returning with new charges. He was going to the AA, NA meetings regularly 3 times a week, was attending church. He was working. He was doing everything that he needed to do. He is now in a much better place than he was in the past due to the sobriety that he's been able to maintain and the support that he finally has. He has, again, like I said, a very large support system of people who are very positive, sober supports to be around. He's been able to enjoy just some of the small things in life that he wasn't able to previously due to addiction. So he really has come such a long way. He is really looking forward to continuing with his sobriety, getting out, continue furthering his business. And eventually he would love to help someone in the future who is struggling currently with sobriety get to the point where he's now at, where he is, sober and is able to help other people. He also does have something that he would like to read. So I would give him the opportunity to do so at this time.
Yeah, absolutely. Go ahead, Mr. Seeley.
Okay, to parole or whom it may concern, please allow, I'm sorry, I'm sick, so I hope you can hear me. Please allow me to begin by saying I'm sure you guys hear statements like this more often than not. However, I feel the need to educate you on my most recent self. First, my whole life I've been in and out of prison and never felt as though I belonged anywhere. Long story short, I married the wrong woman, fell deeper into depression and the world that I've always known. I'm very well aware that leaving the APT program was and is a violation of my parole, and in no way am I saying it was the correct decision. However, leaving there gave me a newfound way of life and opened doors to a life that I've only dreamed of. I found myself surrounded by an immense amount of love and support, unlike anything I've ever experienced before, something I never had with my ex-wife. I fought my way to getting clean and took myself off of methadone and drugs. I have seen and figured out what real happiness is and what it looks like. I look forward to returning to my life. I can honestly say that I would not be back in prison or even close to it if it wasn't for the absconder. I was finally living life positively and working for myself, contributing to my own life as well as my loved ones. In short, I was camping, fishing, laughing, and smiling once again. I have no desire to use drugs or perform criminal acts. I am now in love with a great and special woman and have a huge support system that may have been in place for over 30 years. Finally, I feel I got it right. I sincerely believe that given the opportunity to return home, and I do finally mean the definition of a home this time, that I can and will complete my parole and go on to live a constructive and lucrative life. I was active in NA and AA meetings because my current fiance has over 20 years clean from drugs and alcohol, and it has helped change my life in a whole different way of living. Last time I returned to jail, I had been living life recklessly and came back with numerous new charges. This time, as you know, I have 0 new charges and found myself only with the technical violation of absconder. And I was out in the community for about 10 months. Given my past, I'm sure you know I'm being honest, and if I wasn't, would be back with new charges as have been proven in previous years. I realize that taking responsibility and being held accountable for this violation is something that I need. However, my life has really changed and I still have so much positivity I can share. In here, it's not really doing much. Being in prison isn't doing much for my sobriety because I have nothing to offer. I'm in a different space in my life finally, and I'm 43 years old and need to put prison behind me. There's no help or support here for me, and that's the God's honest truth. I need to return to my incredible family, dogs, children, and life. Thank you so much for hearing me out, and I'd love to answer any questions that you might have.
Thank you. I do appreciate your statement. I do actually have a question. So I do see your attorney did mention you're open to treatment and the 12 steps. It sounds like you were attending regularly, correct, while you were
Yes.
in the community. So reintegrating is that something that's in your plan for sure? Like, what is your plan?
Oh, yes, absolutely. Well, see, the thing is when I mentioned that I married the wrong woman, I had no support there. Okay, like her brothers called my parole officer 110 times, literally. Like if you were to talk to Miss Fortuna. So my plan is to get back out in the community, get back to the 12-step programs that I go to with my girl because she's been clean for a long time.
Okay.
Her father has and is part of my business. If I need the bankroll, he's there. So it's not a question about if I have a job or anything like that.
No, Mr. Seeley, I was just wondering because it says on here interested in reintegrating. I just want to know that you are committed to the AA. That's just what I want to hear. I read the rest of the plan. I did see it. I just want to hear it from you that you are committed to it.
Absolutely.
Yeah, absolutely. Okay. All right. So then I'm going to just take a moment. I'll let you know my recommendation.
Thank you.
Oh, thank you. So again, I have listened to the testimony today, and I reviewed the evidence, and it does sound like you do have a great support system. However, I am going to still recommend your parole be revoked, Mr. Seeley, and that you serve an approximate 6-month sanction, which is a re-parole date of July 31st, 2025. And with that, I'm going to recommend the following conditions: no contact with the co-defendant Clinton Dambois, no contact with the victims SS, MP, HK, BC, and SL, and no operation of a motor vehicle without parole officer's permission. I do have the information for Ms. Anderson as your sponsor. However, Parole and Community Services did ask for halfway house placement stipulation. So I will also recommend that for any backups, but I'm going to input her information first, as that seems like a viable sponsor for you to go to, but it is ultimately their decision, okay? So my recommendation is going to go to the board on March 37th. And on that date, they'll decide whether they're going to impose my sanction. They can actually reduce it if they want to. And if for any reason they would want to increase what I've recommended, there'll be a supplemental hearing held, which means that you'll be notified of it and you'll be present for it because they'll want you to answer some of their questions and concerns. for that to happen. After that date in March, you will be notified of whatever happens during that hearing. So do you have any questions right now, Mr. Seeley?
No, I was just a little disappointed, to be honest. That's all.
So Mr. Seeley, they will let you, so on the 20, you said the 27th is the hearing date. On
Yes.
the 27th, either that afternoon or the following day, if you want like to call my office or have Jennifer call, I can let you know what the board decides. They can give you the amount of time that's recommended. They can give you less time. If they extend the amount of time they want to give you, we would get another hearing. It's very rare, but we would get an additional hearing, okay?
Okay, so another question is, so does that mean that I can't go home? Because the halfway house thing?
Not necessarily. So she's recommending that you go to the sponsor that you identified, but we want to have a backup in case for, whatever reason.
In case she
they
doesn't
end
get
up-
approved?
Yes. So that is what the backup is going to be a halfway house.
Yes.
Okay.
Right.
This-
I can give your partner a call to discuss everything with her. Okay.
Yeah, I'm gonna call her and let her know. I think you can call her after I talk with her. I'm gonna I'm a little disappointed. That's
I
all.
understand. I'll speak with you shortly. Okay.
Yeah.
All right. Take care. Thank you.
Thank
This
you.
concludes a revocation for Mitchell Seeley, inmate number 305213. Thank you, Attorney Dean. I'll see you in a little bit.
Thank you.
All right, thank you. Interesting.
Yeah.
Good morning. Can we please start with Mr. Figueroa?
Of course. Give me one
Great.
second.
Thank you. Morning, Mr. Figueroa. It is 10:58. We just have to wait till exactly 11 a.m. to start, okay? So in 2 minutes, we'll get going.
Okay.
All right, Officer Huff, are you with us? Mr. Huff? Yeah. Officer Huff, are you there? Yes.
Morning.
Good morning, perfect. So, yeah, we'll start in about 2 minutes, okay?
Sounds good.
Thanks.
Sorry for those interruptions earlier. For some reason,
No.
I wasn't muting me.
No worries.
That was in 2024. Right, but what did you live in Pennsylvania, what year?
Yes. Right. Good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning George Figueroa, inmate number 192694. Today is Thursday, March 13, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and MacDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
George Figueroa, 192694.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti and Parole Officer Huff. Attorney Famiglietti, can you please identify yourself for the record?
Yes, I'm Attorney Famiglietti, Rob Famiglietti, Revocation Unit of the Public Defender's Office. Good morning, sir.
Thank you.
Welcome.
And Officer Huff, can you please identify yourself for the record?
Morning, how you doing? Parole Officer Huff, Hartford Special Management Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence. That is, the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Figueroa and Officer Huff, can you both please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yeah.
I do.
Thank you. So I'm going to go over the procedure for the hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find they have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights for today's hearing. The first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice, counsel?
Yes, we do.
And Mr. Figueroa?
I believe you
Yes,
did as
ma'am.
well.
Okay, great. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, we are.
Great. So now we're going to review the charges that the state your parole officer is bringing against you and the underlying information for each charge. Officer Huff, can you please read the charges that you have brought against Mr. Figueroa?
Sure. Charge number 1, no contact with minors. You admitted to having a 4 to 5-year-old female child sleep over at your residence while you were present on December 31st, 2024. This child arrived at your residence the afternoon of December 31st and did not leave until the following morning, January 1st, 2025. At no point in time did you receive permission from your parole officer to have contact of any kind with minor-aged children. This is in violation of your signed conditions of parole, no contact with minors. Charge 2, problem sexual behavior treatment. You admitted to having contact with your son's girlfriend's daughter during claim time in the Center for Treatment of Problem Sexual Behavior, CTPSB group, on January 9th, 2025. Upon further discussion, you stated that the daughter was about 4 to 5 years old and that she slept over your house on the night of December 31st, 2024, and left on the morning of January 1st, 2025. This is in violation of your signed CTPSB treatment agreement, minor restriction.
Thank you. The evidence submitted by the state and the defense at the preliminary hearing were all identified and remain the same. So I just want to confirm, counsel, you and your client did receive the notice of parole violation, the parole violation report, and all the documents that were identified?
Yes, we have.
Great. In addition, I also received new evidence or additional evidence from the defense. I'm going to re-identify them as Exhibit 3, a list of parole accomplishments and future plans for parole reinstatement. Exhibit 4, a letter from Lucia Figueroa, and Exhibit 5, Lucia Figueroa, wife, medical condition. Is that accurate?
Yes.
Okay. Do you need any additional time, counsel, to submit other evidence?
No.
So at this time, we do not have witnesses. So it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Huff, would you like to make any comments towards the charges?
I'm sure. I just want to touch base on what we had discussed during the prelim here, that the defense had previously argued that this offense was not serious enough to warrant revocation. And while I agree there's levels to some conditions and some violations are more serious than others, in this case regarding offender Figueroa, a condition was put in place to protect children and prevent access to potential new victims. This is not a violation based solely upon a curfew violation of a few minutes or an unexcused absence from a treatment group. This is a violation where a person whose instant offense involves having access to a young female child, which ultimately turned into her being sexually abused for about 4 years. His instant offense is why this condition was set in place in hopes of preventing this behavior from occurring in the future. If this is not deemed a serious violation, how else are parole officers to protect the public, in this case children, and hold offenders accountable prior to a new offense being committed? The defense had also previously argued that Figueroa did not know the little girl was in the house, yet during the initial conversation I had with Mr. Figueroa over the phone, he voluntarily stated that the 4 or 5-year-old girl had come over around 4 o'clock on New Year's Eve and left after breakfast on New Year's Day. And then he subsequently wrote a statement attesting to this information and was subsequently remanded as a result. Now, why else would he admit to this behavior if the child was not present and he did not have contact with her? Now that he's being represented by an attorney, the admissions have changed to the only defensible argument for this behavior, that he did not know the 4 to 5-year-old girl was in the house for no less than 16 hours. So it's a little change of a story here anyways. And then this behavior also leads me to have extreme concerns about Figueroa returning home to care for his medically compromised wife, as she was also aware of the conditions and the fact that a little girl was she's aware of his conditions, and the fact that a little girl was able to not only visit the home, but sleep over shows the lack of oversight as a sponsor. The fact that he is considered being considered as a caretaker for her after being home for 11 months, despite being incarcerated for over 11 years, does not excuse the obligation to remove himself from the situation where minors are present in his own home, which is why I'll also be recommending that a halfway house placement stipulation remains on his conditions. And that's all I have for now.
Thank you. Counsel?
Yes, this is a different standard today. It's a preponderance standard. It's not a probable cause. My only argument is that just because the little girl stayed over, she's the daughter of my client's son's girlfriend. Just because he said that she was there doesn't mean they had contact. Mere presence under state for culver is not contact, mere presence alone. This girl was never in danger. There's no allegations that there was any physical contact, that they were in the same room at the same time. Even if you find that it's contact, none of this conduct on behalf of my client was intentional. This was an accident. There was testimony at the preliminary hearing that any time that my client was concerned that something was going to be a problem with the condition of his parole, he reached out to the parole officer and asked. So this, I would classify this as a mistake. Even if you make a finding under the Palmieri standard, he admitted this. He's not trying to hide anything. He's not trying to harm anyone. This is his son's girlfriend's daughter. And let's mind you, this is New Year's Eve. They came down from Massachusetts, stayed late for New Year's Eve, and decided, not my client didn't make this decision. He came home late from work. They decided that he didn't decide, that his son decided that the minor and the mother could stay over. There's no allegation they were in the same room. There's no allegation they slept in the same room. There's no allegation that they talked. There's no evidence of any of those things. Granted, if this is a situation where my client is out in public or even in private seeking out and having illicit contact with the minor, that's one set of circumstances. That I would deem as very serious. And if my client's found sitting in the parking lot during school hours, watching children on a playground or going up to children on a playground, my client is seen going in the mall, going into a toy store. If my client is seen going into public restrooms, having contact with children, that is not this set of circumstances. And there's no allegation, there's no evidence that my client can't remain at his home and take care of his wife. Asking for a condition that he remain in a halfway house, I think, is the problem. My client, so for as far as the charges, I don't believe it meets the preponderance standard because all acts have to be proven to be intentional. This is not an intentional act. Thank you.
Thank you.
This is a mistake.
Before I announce my findings, any additional comments, Officer Huff?
Just real quick, that again, intent is not part of the condition. That is not part of the preponderance standard, if you would. And also the fact that this is in his own private home, where there's very little to no oversight, is extremely concerning. He's not in a park. He's not in the public. He's in his own private home, where who knows what can happen. On New Year's Eve, where people are known to party, known to get out of control. Some people may pass out, and all of a sudden we're talking about something else. We could be in a criminal proceeding right now. But this is the fact that we are here to prevent criminal proceedings from happening. That's my role as a parole officer, is oversee that he is abiding by his conditions and to prevent criminal proceedings from occurring, which is why we're here right now. Thank you.
Absolutely.
Just that one question for the witness. Sir, was there an occasion where my client contacted you prior to drinking for permission that he could have a wine cooler with his wife?
Yes, there was.
Thank you. No additional questions.
Thank you. So I have listened to today's testimony. I did review all of the evidence submitted. And with that, I am going to make a finding on charge number 1, condition of no contact with minors based on state's exhibits B, D, F, and G. And for charge number 2, I'm also making a finding based for condition of problem sexual behavior based on state's exhibits B, D, E, F, and G. So with that, it does conclude the fact-finding portion of today's hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history, and after the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to determine what outcome I would recommend. Officer Huff, any additional information that you'd like to make about Mr. Figueroa's background and history?
No, that's all for now. Like I said, I would just hope to have that halfway house placement stip condition remain on his conditions of parole, please.
Council, it is now your opportunity.
Yes. I don't believe this is a serious violation. I think if something had occurred, or if there's any evidence that something had occurred illicit, then it'd be serious. I don't believe this is the type of individual who was on parole for about a year with absolutely no sanctions for misconduct. It's his first violation. He's been incarcerated now since January 13th. His wife calls me almost weekly saying that she needs him home to help her. She's lucid. She knows exactly what she's talking about. She's confident. She's very with it. She's been a great sponsor. This was a mistake. You don't punish someone for a mistake. No human being is perfect. We should not be held to a 100% standard. Life is not black and white. This is a mistake that happened. My client reported it in treatment, and his history and his conduct is that if he knew this was going to happen, he would have run it by his parole officer, or if he knew it was going to happen, he would have ameliorated the situation. This is him coming home late from work, fixing dinner for his wife, going to the living room, taking a shower, and going to bed, period. They happened to be there, he found that out. There's no alleged interactions. Let's use a different word. No alleged interactions. I'm not arguing this didn't happen. My client admitted it happened. What I'm saying is it's not serious enough to require further incarceration, and it's not serious enough to order him out of his home. Thank you.
Thank you. So I am going to announce my recommendation at this point. And again, I did listen to everything that was stated today. I've also reviewed the evidence submitted. Based on that, I'm going to recommend, Mr. Figueroa, that your parole be revoked. You serve an approximate 3-month period of confinement as a sanction. That's with the reparole date of April 13, 2025. In addition, I'm going to recommend the following conditions: no contact with the victim, CM, enhanced internet and device monitoring, halfway house placement, no contact with minors. I'll get back to the halfway house placement. Problem sexual behavior treatment and restriction on pornography. The only reason I'm doing the halfway house placement is that PCS is adamant on it. So I'm just going to set the stipulation. Unfortunately, it's up to Parole and Community Services to determine sponsorship. So I can't do anything about it. So I am going to grant that stipulation as well, or recommend that stipulation as well to the board. So at this time, my findings and recommendation will go to the board on March 27, 2025. On that date, Mr. Figueroa, the board can do a few things. They can reduce the sanction or give a less time than what I've recommended. They can let it stand and adopt it. Or if they do want to see, if they do have any concerns, want to see you again because they're thinking about giving you more time, there'll be a supplemental hearing where you'll be with them to address their concerns, and they'll give you a decision then, okay? Do you have any questions right now?
No, just give us a call, Mr. Figueroa, on March 28th, or have your wife call us on March 28th, the next day after the hearing. And we'll let you know what the board decided, okay? They have the final say.
Okay. Yeah, thank you.
Keep doing what you're doing. If there's going to be a problem, call your parole officer. If something like this happens again, leave your residence.
Actually, I'm going to change the date because that is a Sunday.
Yep.
So I'll do April 11th.
April 11th.
Okay, so it's approximately a 3-month sanction, but I'm going to recommend April 11th just because
I understand.
it's
Sundays.
a little bit hard for Sundays going on. Okay, so everybody, you understand that?
Oh, is the release date April 11th?
That's the day I'm going to
Oh, I
recommend.
thought you meant for the board date.
No. The board date will stay the same,
Okay.
March 27th. I'm going to recommend a release date of April 11th.
It's March 27th.
Correct. Yeah, because that's the date that they would do.
Okay.
Okay.
Okay, so call us on the 28th of March. Okay, I wish you well. Call me anytime you play. Okay?
All right.
Take
Yeah.
care.
This concludes the final revocation for George Figueroa, inmate number 192694. Thank you, everyone.
Thank you.
Thank you. Have a good day.
You too.
I did, I actually.
One moment, I'll get started. Just wanna note something.
Hasta yo encontrar la dirección bien, también vuelvo a hablar con la dirección.
Good morning. I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning David Sanchez, inmate number 284869. Today is Thursday, March 13th, 2025. And this hearing is being conducted via video at the Board of Pardons and Parole Central Office and MacDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
David Sanchez, 284869.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Attorney Hannah Dean on behalf of Mr. Sanchez. Good morning.
As to the appropriate sanction. The recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Sanchez, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
True.
Thank you. So we're gonna go, you're all set. We're gonna go over the procedure for your hearing now, okay? So first I'm gonna read you your rights. Then we're gonna review the parole violation charges that the state your parole officer is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have important rights at today's hearing, and we're going to go over them now. The first right is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes.
Perfect. You also have the right to review the evidence against you before the hearing. You have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Good. All right, so we're going to go over the charges now that your parole officer has brought against you and the information underlying each charge. So on charge number 1, condition of absconder, the charging officer reported that on 12/12/2023, you signed out of the Central Ave halfway house, your only approved PCS residents, to attend MASC technical training located at 173 Interstate Lane, Waterbury, Connecticut. You were expected to return to Central Ave halfway house at 12:45 p.m. And failed to do so. Staff attempted to contact you on your cell phone and it went straight to voicemail. Local police department and hospitals are contacted and you were not admitted to either. The officer attempted to contact you on your cell phone and was unsuccessful. You have failed to contact staff at Central Ave halfway house and your assigned parole officer, leaving your whereabouts in the community unknown. On charge number 2, condition of travel, the charging officer reported that on 2/3/24, you were apprehended by the U.S. Marshals Violent Felony Warrant Squad in Buffalo, New York. On 12/5/24, you appeared in court in Buffalo, New York, and signed a waiver of extradition. You did not have permission to leave the state of Connecticut. Based on your actions, you're in violation of your release condition. The state has filed the following exhibits that have been marked for identification purposes. That's Exhibit A, the parole violation notice. Exhibit B, the special parole acknowledgement sheet. Exhibit C, the Central Ave halfway house incident report. Exhibit D, the Central Ave halfway house discharge report. Exhibit E, the remand to custody order. Exhibit F, the parolee rights. Exhibit G, the waiver of extradition. And I'm also identifying the parole violation report that was submitted as Exhibit H. In addition, the state filed an addendum to the parole violation report on December 3rd, 2025. 2024. And that's also submitted into evidence and reads as, not 2024, sorry, let me just check that date. So they did submit an addendum. I'm going to clarify the date they submitted it, but I'm going to read it while it loads to get me the date. So it says in reference to the parole violation report submitted by P.O. Jackson regarding David Sanchez, number 284869, the following applies. On January 9th, 2024, the Board of Parole issued a warrant based on that report declaring the offender as an absconder from special parole supervision. On January 12th, 2024, the case was transferred to FIU for investigation, and on 12/3/2024, Sanchez was apprehended by the Buffalo Police Department as USMS Violent Felony Warrant Squad. A detainer was lodged with Buffalo Police Department. Sanchez was served his parole violation notice on 1/3/2025, and the signed notice of parole violation, parole rights, and remand were scanned into case notes on 1/6/2025, and that addendum was submitted on December 3rd, 2024. So counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
Great. I have received exhibits from the defense, and I'm gonna accept them as well. And I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, a letter from Gina Casillas. Exhibit 3, a letter from employer Charles Lockwood. Exhibit 4, utilities bill with client's name. That's 2 pages. Is that accurate, counsel?
Yes, that's right.
Great. Do you need any additional time to submit other evidence?
No, we don't.
Okay, so say we do not have any witnesses. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges or any of the evidence submitted.
Thank you very much. I just have some global comments as to both the charges. So this is an unfortunate situation that led to this current parole violation. At the time of the alleged violation, my client was serving a number of sentences, which, for lack of a better way to put it, were very, very confusing to understand. I was able to contact Central Records in the clerk's office, actually out of the court where he had taken one of the pleas, to get a sense of what the situation was and to figure out what his supervision situation was, because my client was not under the impression that he was on special parole. He was under the impression that on 12/12/23, when this alleged violation occurred, that was his discharge date and he had no additional supervision. I did contact, like I said, Central Records in the court, and I was able to find out that the instant special parole period actually stems from a September 2017 conviction out of Danbury Court, where he got 3 years to serve 3 years special parole. Then he subsequently got a file out of Bristol, disposed of in November of that year, where he got 29 months consecutive to the time that he had already gotten out of Danbury. Thereafter, in June 2018, he got 6.5 years as well out of Waterbury. So effectively, my client had begun serving his Danbury, Bristol, and Waterbury sentences, eventually got discretionary parole, but didn't actually start his period of special parole supervision until he had discharged on all the other sentences because of that one consecutive sentence. So I will just give it to Mr. Sanchez. I've been doing this for a little while and I had a hard time figuring out what was going on here. And so I don't think that this was a situation where he was intentionally trying to elude supervision. I think it was a genuine mistake due to the complex nature of his sentencing. Additionally, due to the sort of lapse in time, to no fault of his own, he thought that he had finished all supervision. Again, when he left on 12/12, he didn't think that he had any additional supervision. I also just want to note that as to the preponderance standard, there are just a couple quirks in the evidence that I want to point out. I think it's relevant to note that on his special parole acknowledgement sheet, Exhibit B, that was signed all the way back in April of 2023 when he was on his discretionary parole. So that was 8 months before he was even scheduled to begin special parole, and it doesn't contain any specifics whatsoever about when the period of special parole is to start or what the duration of that period would be. Actually, at the top of that exhibit, it says under the acknowledgement, I will begin 0 years, 0 months, and 0 days of special parole supervision. So I would argue that the signed acknowledgement doesn't sufficiently show that my client was apprised of the period of supervision and knowingly consented to the rules for a specified period of time there. This information doesn't rise to that level. Further, based on the conversations that I've had with both my client and his wife, I have good reason to believe that his PO knew he was going to leave Buffalo as of 12/12, or leave to Buffalo as of 12/12/23. So my understanding is that my client had spoken with her a couple different times. She had said, "Your plan's still to go to Buffalo. What are you going to do in a couple weeks?" It seems like there was confusion on not just my client's end, but on the side of numerous parties as to the situation with this supervision. So my client, I think, was under the impression that he had permission to go. He, again, didn't even think that he was absconding because he didn't think he had any supervision left. It sounds like there was some confusion on the part of all parties. So I would just like to make all of that information. Additionally, my client and his wife noted that it says in the report that he was called, but they both note that he didn't receive any calls for the duration of a couple months after he had left the halfway house. He eventually got a new phone in New York, but he indicates that he had the same phone for quite some time and hadn't had anyone reach out to them. So I do just want to make note of all of that. It's somewhat of a unique situation here. And at the appropriate time, I would like to speak to his background. Thank you.
Thank you. I'm just going to take a moment to process the information, and I'll let you know my findings. So I have listened to the testimony today, and I did review the evidence that was submitted. Based on that, I am going to find that for charge number 1, that you've violated the condition of absconder based on the evidence presented in exhibits B, C, D, and H. And for charge number 2, I'm also finding that you violated the condition of travel based on state's exhibits B, H, and G. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have the opportunity to speak to your background and history. And the purpose of this part of the revocation is to help you determine the outcome I will recommend. So counsel, would you like to make a statement?
Yes, thank you very much. My client, Mr. Sanchez, is 51 years old. He was originally born in Vallarta, Puerto Rico, and raised in Buffalo, New York, prior to moving to Waterbury, Connecticut in 2000. His entire support system resides in Buffalo, New York, which includes his wife, Ms. Casillas, his 3 daughters, his mom, 2 sisters, aunts, and various cousins and friends. My client also has assumed the role of stepfather to his partner's son, attending his football games and lacrosse practices and games. My client receives additional support as well from his landlord, Mr. Lockwood. He recently experienced the loss, very unfortunately, of his nephew in November of 2024. Actually, it was very tragic. I believe his nephew had passed on, I think it was a Thursday. And then the following Monday is actually when my client was remanded to custody, and he unfortunately didn't get to say goodbye, go to the funeral. Upon release of community supervision, my client was at Renaissance Central in Waterbury. He completed CNC machining and 3D printing programs at Mask in Waterbury. In Buffalo, he was working with his landlord, Mr. Lockwood, doing various handyman tasks. That's Exhibit 3 that we had submitted. As noted in the state's Exhibit D, my client successfully completed IOP while on supervision in July of 2023. He also did 8-year analysis while at the program and was negative in every single one. He does have a significant medical history. This includes kidney disease, celiac disease, high blood pressure. Those are managed by medication. He also is on dialysis. He dialyzes 3 times a week for 4 hours each day. He reports helping out at his church in Buffalo, New York on Sundays, helping provide food to the community. While incarcerated, my client has been undergoing dialysis 3 times a week, again, 4 hours each day. Upon reinstatement of his parole, he would like to go through the process to have it transferred over to New York so that he can reside with his partner, Ms. Casillas in Buffalo. Should he need a halfway house in the interim, I believe he's requesting the Waterbury jurisdiction. Is that correct, sir? Or
Yes.
did you want? Yes, so he is, I believe, asking for the Waterbury jurisdiction, and I would just ask that he kind of be on the radar for the interstate compact situation, since his whole support system is out of state. Should he be placed in a halfway house? Oh, sorry, we already covered that. He requests Waterbury. He wants to further his CNC machining and 3D printing education and eventually get a job in one of those two fields. If he's granted the opportunity to transfer to New York, he would go back to work with his landlord, Mr. Lockwood. He's very eager to reunite with his family and his friends. He's amenable to any treatment and is looking forward to attending to his medical needs in the community. I would argue this isn't a situation where my client had intentionally absconded. Again, I think that there was a large amount of confusion as to the supervision from a number of different parties here. I believe this whole situation was a true mistake. My client was doing great while in the community. He had no reason to leave. He was not eluding police. He was working. He was attending church. He was tending to his medical needs, helping his family. He even had his name and information on power bills. If he was eluding supervision, why would he provide his name knowingly like that, where he could easily be found? He was compliant with extradition once he was apprehended. He waived immediately. He's just looking forward to getting back home so that he can keep doing what he was doing and continue forward in a positive manner. This is his first violation. There weren't any other issues. He was doing what he needed to do. I would ask for the soonest re-parole date for him. I would also request that you consider the amount of time he's been incarcerated altogether, not just in Connecticut, because he was held in New York, I believe, for about a month or so before the extradition actually occurred to Connecticut. I believe 12/3/25 or 24, I should say, is the date that he was actually apprehended. And then he then went to court on the 5th, 12/5, and waived extradition. So I would ask in considering a sanction that you take into account that amount of time. Thank you very much.
Thank you. I guess that I just want to confirm, because you're right. I think I did read that in the addendum. They apprehended him 12/3, right?
Yes. And then I think he went to court. I think that was a weekend, and then he went to court the following week.
Yeah. Okay. Yeah. Okay, so I have listened to the testimony and I did review the evidence submitted. With that, I am going to recommend Mr. Sanchez, your parole be revoked and that you serve an approximate 4-month sanction, but I am going to consider that time in that you were incarcerated in Buffalo. So that's with the re-parole date of April 3rd, 2025. I'm going to recommend the following conditions: no alcoholic beverage consumption and halfway house placement. I just want you to be aware, Mr. Sanchez, normal practice is you have to be compliant for about 3 months before you start having the conversation with their officer. So as long as you're doing well for 3 months, you can talk to them, ask them about the interstate process and start the paperwork rolling. It is unfortunately a lengthy situation because once that conversation happens, we have to then get a request out to New York. They have to accept you. So you just kind of have to be patient with it, okay, if that is your goal. But that is my recommendation. Go ahead, sorry.
I was just gonna say, and in the meantime, if for any reason you need to go tend to family stuff, just make sure you communicate that and get permission from your parole officer, okay?
Yes, permission. Make sure you have that written permission. Don't come back for that, okay? Yeah, don't come back for that. But as long as you're doing well and it sounds like you were doing okay, like
I'm doing good.
so I don't see, at least get the process going to have to get back out there to your family and everything. So my findings are going to go to the board on, that's not the right date, March 27th. On that date, the board can do a few things. They can lessen my recommended sanction, which will only be about 2 weeks at that point. They can adopt my recommended sanction, or if they want to, if they have any interest in doing any additional time, that what I said, a supplemental hearing will be held. You'll be notified of that. You'll be present for that hearing to address their concerns, and they'll give you a decision then, okay? If that happens, but if not, after the 27th of March, you'll be notified by us what their decision was, okay? Do you have any questions right now?
No, ma'am.
No, good. Everyone's good. All right, great. So this does conclude the revocation hearing for David Sanchez, inmate number 284869. All right, thank you, Attorney Dean. Thank you, Mr. Sanchez.
Thank you very much. Mr. Sanchez, if you want to call my office the afternoon of the 27th, we can let you know what they decide, okay?
All right, thank you.
All right, thank
Have a
you.
nice
Take
day.
care.
You too.
Thank you. I think I'm with you, right? Oh, we're
Yeah.
not till
at
12.
noon.
Yeah, okay, I'll be back.
All right, sounds
All
good.
right, bye.
Officer Trusello, if you're ready, I'm gonna call Osborn.
Okay, sounds good. Thank you. Attorney Dean, I don't know if we have vocalized this at all to you, but Osborn is, has no internet as well as Carl Robinson. Yeah, so
okay.
we're gonna do it by phone if that's okay, unless you have other thoughts or plans.
Yeah.
That's okay?
That's fine. Do I need to call in separate or can this all be connected by a phone?
Kristen's doing it by phone now. Yep, we got him on.
Perfect. Thank
Officer
you.
Williams, if you can press *6 if you can hear me. It looks like Osborn is now unmuted.
Hi.
Perfect,
Hi,
we can hear you.
Yes.
Can you hear me?
Yep, we can.
Okay, I have Lozada here.
Thank you.
Okay, give me 1 second.
Uh-oh.
It might be a delay when you're talking.
All right. Hello.
Hi, Mr. Lozada.
How you doing?
Good. So it is 11:56 right now. Unfortunately, we cannot start until exactly 12 o'clock. Okay, so in about 4 minutes, we'll get going.
All right.
All right. Thank you.
You're welcome.